Let's switch gears here. We're going to talk about reproductive rights, certainly an issue dividing the state of Michigan right now. As you're well aware, there's a law that's currently on the books. It's from 1931. It bans most abortions in the state. That law, though, became unenforceable in 1973, of course, because of the Supreme Court's Roe v. Wade ruling. But that could change this year. And Planned Parenthood of Michigan and Governor Whitmer, they've filed lawsuits to block this 1930s law if the Supreme Court weakens or even overturns Roe v. Wade. You've said that your office is not going to defend Michigan in this case because of your own personal experience, and you've been open about it, and I'll just say you were pregnant with triplets at the time. How did that frame your position that this law is harmful to women?
Well, I've always believed that women should have the right to have bodily autonomy, and that those kinds of difficult decisions should be between a woman and her physician or a woman and her family. Certainly, politicians in our state should not be able to place themselves either within an individual's doctor's office and be making those decisions on behalf of women. My decision not to defend the law wasn't based so much on my personal experience, although I thought it was important to share that, but on the experiences of thousands and thousands of women around our state, and the understanding that not only do I believe that law to be unconstitutional, but I know that for certain, if it is enforced, women in my state will die. We have 2.2 million women in our state of reproductive age, and many of them will face death or great bodily harm in the event that prosecutors in our state are permitted to begin enforcing this law. And it is for that reason that it is unconscionable to me to defend this law. I have invited the Republican legislature to come on in and defend the law. They frequently seek to intervene in my cases. But interestingly enough, even though this was a week and a half ago that this case was filed, it's been crickets. I've reached out to the Republican legislature.
What is that? I was going to ask you about that. I mean, that's surprising, yeah?
Yeah, I mean, considering you have a party that all of the AG candidates that seek to unseat me have said that they will vigorously enforce this law, the state legislature seems to have no interest in actually defending it. So even they possibly see that this is an indefensible law and that it is unconstitutional. Otherwise, I think they would intervene. And so far, we haven't heard anything from them.
Yeah. Well, you're well aware several states, in fact, are preparing to pass their own set of restrictive abortion laws. This, again, ahead of the Supreme Court's decision in the Mississippi case. How concerning is this to you overall? And do you think Michigan could also enact its own version if the Supreme Court sides with Mississippi?
Well, that's the thing. We don't need our own version. We already have that law in the books. So all we have to do is, I mean, as we know with the Mississippi law, the Texas law, I mean, these cases are pending before the United States Supreme Court. At any time, if Roe v. Wade is overturned, automatically this 1931 law will spring back into effect. So there's no need for the legislature to do anything in our state. Abortion, in almost every case, will become not just illegal, but, a prosecutable offense, a felony in our state, which means that I think that doctors, even in the most serious sets of circumstances, will be very hesitant to uphold their Hippocratic oath and to assist women when they're facing grievous bodily harm or even death, because they'll be so afraid of going to prison. And that is incredibly concerning to me, and it should be concerning to everyone in my state.
Yeah. Michigan Attorney General Dana Nessel, I've got a lot of respect for the job you do. Thank you for coming on the show. It's good to see you. Thanks.